Hello, everyone. I'm Larry Haven, Professor Emeritus of Industrial Relations at St. Mary's University in Halifax and former President of the Canadian Industrial Relations Association. CIRA is an organization of industrial relations academics and practitioners who work in places like government, unions, employers, and the law. If you're in any of those groups and you're not members of CIRA, we invite you to join. You might be interested in our annual conference, which this year is at the University of British Columbia in Vancouver from June 5th to 7th. Our website, you can see on the display of the screens, cira-acri.ca. This is the 5th series of webinars on industrial relations issues brought to you by CIRA. It's the 5th season. Some of the past guests have been Canadian Labour Congress President Hassan Yousaf, Professor Eric Tucker of Osgoode Hall Law School, in Toronto, author Jane McAlevey, the former CEO of the NHL Players Association, Alex Dagg, Professor Sheila Campbell of the University of Regina, and some of these webinars are available at the CIRA website. We recorded them. If you go to the CIRA website and you click on webinars, you should see several of them which you can watch and or listen to. So, folks, our topic today is unions and member-on-member misbehavior. What is workplace bullying and why is the problem so intractable? And what about in the unionized workplace? As accomplished as unions are in defending their members from wrongful discipline by employers, unions are often confounded when it comes to member-on-member bullying or discrimination or other forms of misbehavior. Why is this issue a kind of kryptonite, a substance that in the comic book turns Superman into a weakling? Why is this a kind of kryptonite for unions? Why do some unions handle this poorly and others better? How could unions do better? What happens when there are other regulatory regimes like human rights commissions available to complainants? What recourse is there for union members if their union will not represent them to their satisfaction? Two knowledgeable academics are with us today to explore the issues. And now for a brief biography of our two panelists. Celeste Grimard, PhD, Manitoba, is a professor at École des Sciences de la Gestion at Universite du Quebec à Montreal, where she offers courses in leadership, organizational behavior, and management skills. Her research areas include civility and bullying in the workplace, emotional labor, and burnout. She's published and presented her research in a variety of journals and books and conferences. She recently published books on the topics of incivility in the classroom and at work, management skills, and leadership skills. Prior to working in academia, for 20 years, Celeste worked in organizational and human resource development for Health Canada, the Saskatchewan Property Management Corporation, and the City of Regina. Celeste will give us a general introduction to bullying in the workplace. Claire Mumme, MA, LLB, LLM, PhD, is an associate professor of law at the University of Windsor. She teaches and writes regularly in the areas of employment, labor, and human rights law. Her research focuses on the law's distributional effects, and she is currently involved in a number of projects examining labor, employment, and human rights law's responses to changing forms of domestic and translational work and production. Claire will delve into how unions deal with human rights complaints, and especially member-on-member misbehavior. So Celeste will be the first up, and give me a second here, and I will change her into the presenter so that she can present her slideshow. Go ahead, Claire.
I think it's me. Well, thank you for the introduction, Larry.
Sorry, Celeste.
That's okay. Thanks for inviting me to participate in this webinar. I hope to share with you some of the insights that I've developed as a researcher, but also as an intervener on the topic of bullying and incivility. When we're talking about misbehavior in the workplace, we tend to consider 4 categories of behaviors. We tend to consider violence, aggression, bullying, and incivility. And these behaviors really exist on a continuum. They increase in severity, intensity, and escalate as you move towards violence in the workplace. Moreover, they're more noticeable, verifiable by a third party, harmful, and actionable as you move toward violence. In other words, although uncivil behaviors are inappropriate, it can be really challenging for individuals to recognize and agree that the behaviors are indeed uncivil and harmful. Uncivil behaviors tend to be fairly frequent and ambiguous. And what we've noticed is that if organizations allow incivility to continue, then we see bullying. And if bullying is allowed to continue, then we tend to see aggression. And aggression inevitably leads to violence. All of these behaviors demonstrate a lack of respect for others. People engage in them either out of ignorance, they really don't know what they're doing, that they're not aware that what they're doing is inappropriate, or malice. They know the impact of their behaviors, they know it's inappropriate, but they engage in them deliberately with intent to harm. So the question becomes, how do I know if I'm being bullied? Well, you're being bullied when you've been the target of a pattern of negative or hostile behaviors over a period of time. These could be several different behaviors or the repetition of a single behavior. The intention of the bully isn't in question. Bullying tends to be dispute-related and quite predatory. So you likely have been bullied when all of the following criteria have been met. Has negative hostile behavior taken place? Has it been repeated? Has your personal integrity and personal dignity suffered? Has the behavior created a very hostile working environment for you and possibly others? So you may be wondering how long or how often the behaviors must occur before you can call them bullying. And there's a bit of a controversy about that. There's really no agreed upon frequency or duration of behaviors. For example, the behaviors could take place once a week over a period of 6 months, once a month for 6 months, or even every now and then over a 6-month period. It's really a matter of your own subjective perceptions and whether a reasonable person, an objective third party, would consider the pattern of behaviors to be bullying. But let's talk about what bullying is not. It's not a demanding boss. Demanding bosses tend to have high expectations, but they don't diminish your feelings of dignity. I've intervened in a couple of cases where employees were accusing their new managers of being a bully. And it's often in times of transition when we see accusations of bullying. In one case, after investigation, I found that the manager was adopting a style that was really quite different from that of the previous manager, who was really easygoing and actually friends with the employees. In fact, the previous manager had such low expectations for performance that the reasonable expectations of the new manager felt unreasonable to the employees. In the second case, a group of employees were the bullies. They were actually bullying the new manager because she was hired from the outside, and an employee who had applied for the manager's position but didn't get it was quite angry. So she was organizing people around her and against this new manager, and she decided to make a formal complaint against this new manager. In fact, I've seen this pattern elsewhere, where people who are doing the bullying launch a preemptive strike and declare themselves as targets of bullying. And this happens because the first party to complain often has more credibility. So it's really careful. It's really important that you be careful when you're intervening on behalf of the bully or the targets to ensure that you have the facts of the situation. Next, bullying doesn't consist of poor communications. Some people miscommunicate, but it's clear that they have good intentions, that they are reasonable, and they're just lacking in skills or they're under a lot of pressure. And bullying is not normal conflict. You should be able to work it out if it's a normal conflict where both parties are being reasonable. However, if that conflict is left unresolved over time, it may escalate into dispute-related bullying. So conflict can become bullying. I like to think that there are 3 levels of bullying. And I think that the nature of the tactics gradually evolve from indirect to direct, from omission to commission, and then from being ambiguous and subtle to clear and obvious. And the frequency and intensity of the tactics tend to escalate in a vicious cycle if they're left unchecked. And that tends to result in a reduced coping ability and increased withdrawal on the part of the target. The target tends to be accused of not being a team player because the targets often withdraw because they're trying to understand what's going on. And the target feels increasingly vulnerable. So we're going to look at each of these levels individually. So level 1 refers to indirect, moderately aggressive bullying. It involves denying your existence. So that's where the bully and perhaps others may be ignoring or excluding you, not including you in decisions or in meetings or activities that are very important. Showing little or no interest in your opinion. You may be saying something, but they start to talk or just completely don't respond to what you're saying. They may be failing to respond to your phone calls, your memos, or your emails, so they're stonewalling. They may withhold information that you need to do your job. They might isolate you from your colleagues. Second, the bully may fail to support you, and this involves delaying work or causing others to delay action in a way that makes you look bad. This may involve using, hiding, or removing resources that you need to get your job done. They may be ignoring you or your contributions. And also it involves not providing you with credit when it's due. They may be reacting to you with sighs, frowns, or rolled eyes. So this is level 1. It's indirect, moderately aggressive. It's where you feel that there's something off, something not quite right that's going on, but you're not quite sure, and you don't feel that it's all that significant. You don't feel that you have a case now, if anything. Well, level 2 becomes more direct and escalating. The behaviors become a lot more obvious. And it's really important that you document everything that's happening all along the way so you can start to see the patterns yourself. Otherwise, all you see are these isolated behaviors, and you don't make much of them. The fact that someone didn't look at you or roll their eyes when you were talking to them, that doesn't seem that significant, but when you see it in the context of all the other behaviors, you can see that there's a pattern. So level 2 involves direct aggression. For example, putting you down, which involves interrupting or preventing you from expressing yourself, belittling and undermining you. That may involve making jokes at your expense. It involves questioning your decisions. They never agree to anything that you have to say, even though it may be the same thing someone else says afterwards. It also involves using demeaning nonverbals, such as glaring at you, hovering over you, giving you dirty looks. It involves undermining your ability to do work. And this could happen by, they could do this by overloading you with work in terms of the quality expectations and the quantity of work. They may set impossible deadlines. They may be sabotaging your success in some way. They may be spying on you, so they may be engaging in excessive monitoring of your work. They may remove the items that you need from your workstation to do your job. There's level 3, and by this point there should be no question that in your mind, if you are the target, that you are being targeted by a bully. It involves direct, severely aggressive bullying, and this involves damaging your reputation by putting you down or humiliating you in front of others, taking credit for your work, fabricating a case against you, blaming the work unit's problems on you, so choosing you as a scapegoat for all that's going wrong, spreading rumors or lies about you. It may also involve verbally abusing you, such as yelling, swearing, making angry outbursts, threatening you, and finally it might also involve physically abusing you. So it doesn't have to involve all of these, but it may involve, it may happen to involve all of these by pushing you, grabbing, throwing items at you, slamming the fist down on objects on the table, and so on. So instilling fear in you in some way. So that leads us to ask, what triggers bullying? So what's at the bottom of bullying? And I wrote an article about this in the Teen Performance Management Journal called Explaining Bullying. I looked at a variety of theories that would help us understand why bullying might exist in organizations. So there are a few things we need to keep in mind. You've probably heard this, that behavior is a function of the person and the situation. So if we're looking for a cause, it's really important to look at both the context and the individuals that are involved. And secondly, no one factor is likely to be bullying. There are usually multiple triggers interacting in a situation. Finally, there's no standard profile of a bully. I'm not going to go into what bullies are like or what targets are like, but there really isn't a standard profile. And as a result, we can't try to eliminate them through the selection process. There's too much happening, too much bullying happening in organizations for it to be caused entirely by personality disorders of some sort. And we know that the context is quite important. So how does bullying affect its targets? Well, as you probably know, it affects them on many, many levels. Their mental health is affected. They may suffer from depression, anxiety, reduced motivation and satisfaction. They may even contemplate suicide. They tend to feel shame, humiliation, invalidation, embarrassment, a great deal of embarrassment, confusion, and doubt. They may start to ask themselves, well, why me? And what did I do wrong? Am I imagining this? And they certainly ask that last question because they think that it may just be them. They start to blame themselves. Physically, they may develop musculoskeletal health problems or gastrointestinal problems. They may have trouble sleeping. They may have nightmares. Behaviorally, they tend to take more sick leave. Their performance levels may drop as they become consumed with confusion about what's happening. And they may become increasingly isolated because they may try to avoid others because they feel shame or embarrassment. Or others may avoid them for fear of becoming the target of bullying themselves. If the bully is quite powerful and notices who hangs around with who, some individuals, some coworkers may start avoiding the targets because they don't want to become the next targets themselves. Finally, targets may leave the organization or intend to leave the organization. And you may have heard that targets tend to suffer from post-traumatic stress disorder, especially if it has occurred for a long time. So 75% of targets of long-term bullying suffer from PTSD, and 65% of targets 5 years after bullying still experience PTSD. So it's something that stays with people for a long time. They're always questioning, what could I have done differently? What happened? They're trying to, they're reliving the event. They're hyper alert and sensitive. They tend to be fatalistic. They become emotionally numb, and they experience anxiety, nightmares, insomnia, and very poor concentration, and possibly uncontrolled acting out because they really don't know what's going on. They're trying to make sense of it. They may experience periods of intensive anxiety or panic, and they tend to avoid situations associated with the trauma. For example, one target told me she used to make sure she never walked in front of the office of her bully, even though it would mean it would take her an extra 5 minutes to get to her office. So what should I do if I'm being bullied? Well, we could change the target by educating them, for example, by helping them become aware of what bullying is and perhaps helping them develop some skills for coping with the bullying. But this tends to be reactive. It tends to obscure who is really to blame, and it doesn't prevent the bullying from occurring. You can try to change the bullying by talking to them, so help them become aware of their behaviors. Let them know that what they're doing is bullying. You can try to change them through training and education, or by grading, which involves taking disciplinary measures. I haven't seen that very often. More often than not, what I've seen is that the target has been removed from the workplace and moved to another section, which in a way is equivalent of punishing the target. Finally, you can change the system by changing the dominant culture and the climate that promotes, that supports bullying. And that occurs when bullying is permitted, ignored, or rewarded, when the management style that is used is aggressive and it tends to be valued, especially by upper management, when interpersonal conflicts are persistent and they haven't been addressed, when the workplace is stress intensive, and when there is little teamwork, when people are expected to compete with each other. So here's a decision tree that targets of bullying might use. There's just a huge variety of things that targets can do, and often the first question is that of whether to stay or to leave.
Sorry to interrupt, Celeste. I just want to make sure that you know that you have about 2 minutes left.
Oh my goodness. Thank you very much.
To signal you by messaging, but I guess it doesn't work. Sorry.
No. Okay, I'll try to be quicker.
Thank you.
So there's a variety of things that targets can do, and some are more appropriate and effective than others. But the first thing is to assess your situation and know when you've been bullied, know what your rights are, don't ignore your gut feelings, do your research, try to find out if this person is a serial bully. Sometimes it may be appropriate to ignore the behavior if the behavior is out of character for the person and if it doesn't seem important, but if the behavior becomes a pattern, it's important to act immediately. You also need to shore up your resources, maintain your personal competence, ensure that you're continuing to be competent on the job, and seek support. Don't isolate yourself. One of the main things you can do, though, is to document. Keep thorough records of what has happened. Try to get written statements from the witnesses. Also, your records should include your efforts to deal with the bully, your own reactions, behaviors, and what you've done. The next thing you should do is try to start with informal approaches by standing up if the bully is standing and using all the tools that you've learned in your constructive communication classes. So be specific in describing the inappropriate behaviors and what treatment you expect. Don't let the inappropriate behaviors slide by. Ask for clarifications, for specifics. For example, saying, please clarify what the problem is so I can address it. Please speak with respect. Or ask, what did you say? Often bullies are reluctant to repeat what they've said. Now, a sample of mediators told me that what they would avoid doing is avoiding the bully, avoid being compliant, avoid completely agreeing with your bully, and avoid retaliating, although we see that next. And if these informal approaches don't work, it's important to move on to formal approaches, such as preparing a written complaint. I think it's, I think it's really important that targets seek support from their union representatives who have a duty to support their members. Whether this means helping targets develop coping skills and ensuring that targets are properly documenting what is happening, advising targets about the process to follow within the organization, and guiding targets throughout this process. They should be accompanying targets to meetings intended to resolve the issues and advocating on behalf of the target. So there's lots that unions can do to help employees. And if you see other people being bullied, you should ask if there is a need to act, and then consider whether it is appropriate to act. Quite often, observers think that there's a high risk of acting because they'll get on the bully's bad side, so they don't want to be targeted. And also, they might be politically aligned with the bully and support the bully's action, or they might target, they might blame the target in some way. So based on this decision tree, the researchers suggested that there are really 4 courses of action. And this is my last couple of sentences, Larry. If the observer chooses low involvement and acting later, it includes helping the target by giving advice but not getting involved directly. In contrast, high involvement and acting now involves directly confronting the bully about their behavior, supporting the target publicly, and getting others to denounce the bully. So as you can see, that there are other options in the diagram: intervening later or trying to redirect the bully's attention. Observers are often loath to intervene because they don't want to become the target of bullying. And I think that eliminating bullying and other misbehaviors is a question of everyone getting involved and taking responsibility, including observers. It's important to have the courage to confront it. So I'll conclude my presentation with a quote from Dante: "The hottest places in hell are reserved for those who, in time of great moral crises, maintain their neutrality. What will you do?"
Thank you so much, Celeste.
Oh, you're welcome.
Yeah, I got to figure out a couple of things about GoToWebinars, such as how to wave and tell speakers that the audience can't see. So I'll try and figure it out. Our next speaker is Claire Mumme, who I've introduced along with Celeste right at the beginning. So I will just bear with me. I'll just change presenter over to Claire. And Claire, go ahead.
Trying to get my PowerPoint up. Is it visible on the screen? Yes. Yeah. Okay. So, hello everybody from snowy Windsor, Ontario. My job today is to talk about situations where the kind of misconduct and bullying that Celeste has described is between members within a bargaining unit. So, situations of unionized workplaces where the alleged bully is also a member of the union, which is an incredibly complex situation for a union to address. Now, I'm going to focus my analysis on situations of member-on-member discrimination situations. And so by this, I mean, harassment related to what are referred to in this, as prohibited grounds of discrimination: race, sex, sexual orientation, place of origin, language, disability, etc. So I'm going to focus on that context specifically. And my remarks are aimed primarily at unions who are trying to figure out their way through their representational obligations, because the difficulty in member discrimination situations is that the union owes both members a duty of fair representation, even though the interest of those two members conflict. And so what I'm going to do is try and lay out the legal framework within which that sets out obligations that the union has to try and figure out how to operationalize, and then talk about why it's particularly confusing in the member-on-member situation and some ideas to think about further. So I'm a lawyer, so I come at this through legal means. I should also say that because I'm a lawyer, my slides are a bit wordy, and I do apologize for that. But I came to this topic a few years ago after witnessing a situation play out in a workplace and in a university. And the situation that happened was that there was a racialized student who revealed to a number of female faculty members that she had been being sexually harassed by one of their co-workers, a male racialized faculty member. But the student was too afraid to come forward, and so the women faculty members brought it forward on her behalf to the university. And then the student from there made a formal complaint. The university hired an independent investigator. They dismissed the male faculty member. The union brought a grievance on his behalf, grieving his dismissal, and they eventually settled, right? A relatively, a not infrequent scenario. But what I found particularly interesting is that the female faculty members who had brought forward the complaint were really flabbergasted by the union's approach. And I tried to explain that, the union would view the weaker party as being the employee was disciplined because they're thinking about it, as between an employee and the stronger power of the employer. And also that they would probably view the interests of the students and of the complaining faculty members as being aligned with management, so as being properly represented there. But as I was saying that, I realized that the framing of the issue in that way doesn't fully encompass the interests at stake. And the effect of that was actually to really disenfranchise or to turn a group of workers against the union. And so the faculty members who had brought the complaint understood themselves and the student as being the marginalized party in need of support. But they were only at this point witnesses. Nonetheless, they felt they had really put themselves on the line in bringing this issue forward. They received no information from the employer or from the union. They were worried. They didn't know what, being a witness was going to look like. They were worried about what would happen if the faculty member at issue, the alleged harasser, came back into the workplace knowing that they were the ones that brought it forward. And the end result has been that those faculty members those female faculty members felt totally betrayed by the union, even though the union did the kind of standard things in this context, right? These women were not the complainants officially, so there was no official member-on-member scenario. But the women now either felt that the union does not care about issues of sexual harassment, or some of them felt that actually the only party that cared about the situation was the employer, and so they now viewed themselves as aligned with the employer. And that seemed to me not only actually strategically disastrous for the union. Again, I think the union did the kind of standard thing in this scenario, but the logic behind it was unconvincing to the women involved, and they've never come back to the union. They don't come for strike votes, they don't come to the picket lines, and they don't think that the union is an institution that cares about discrimination in the workplace. And so that's what pushed me into thinking about these questions. Because it seems to me that the way a union handles member-on-member discrimination claims really may jeopardize its legitimacy as being viewed as an entity that cares about issues of structural racism, and may push more marginalized workers away from seeing the union as their home. And that seems to me a really dangerous scenario for a union. So let me just then shift into thinking about, what law is there here? And what I'll advise is a series of independent obligations that the union holds, because there's no specific legal rules about how a union should address member-on-member discrimination as opposed to another situation where the discrimination comes from management. Instead, there are a series of independent legal obligations that the union holds towards its members and in its relationship with the employer, and it has to figure out how to operationalize those when the members themselves are opposed in interest. So what I'm going to do is briefly talk about unions' representational obligations towards their members, both from the duty of fair representation and under the Human Rights Code. And then talk about a slightly different question, which is what role does the union play in addressing workplace discrimination? So discrimination that or not in their own representation, but in discrimination that happens more broadly in the workplace. And then how does that shift? How does that sort of traditional view of the role of the union in addressing workplace discrimination shift when both complainant and alleged harasser or alleged discriminator are in the same bargaining unit? And finally, what questions should we be asking ourselves in addressing these situations going forward? So as most of you will know, a union owes each member of its bargaining unit a duty of fair representation. This is statutorily required in most provinces. In some, it's been developed through case law. And the requirement is that the union not act in bad faith, be discriminatory, or act arbitrarily. And I've set out in the slides some brief descriptions of what those three things mean, but in the interest of time, I'll skip over that to focus in on the question of discrimination. So the union is obliged to not represent in a manner that is discriminatory. And what that means in the duty of fair representation context is that they can't impose differential treatment without a legitimate labor relations reason. So that covers situations also covered under the Human Rights Code, but it's broader. It's a broader prohibition. Issues often arise also in regards to arbitrariness, a question of whether the union's efforts have been sufficient in dealing with a discrimination question, and that's often caught under the arbitrariness prohibition. Now, unions are not required to be perfect. The case law is quite clear that unions couldn't operate if they were under constant scrutiny of all of their decisions, particularly with smaller unions who may have less training and less experience. What they are is held to a standard of reasonableness. So unions owe a duty to each member to represent them in a way that is not in bad faith, discriminatory, or arbitrary. And unions also owe a duty to represent their members in a non-discriminatory fashion under the provincial human rights codes. And what this requires is that in the manner of the union's representation, they not engage in differential treatment or make decisions that have a differential impact on someone on the basis of a prohibited ground of discrimination, on the basis of their race or sex or sexual orientation or sexual identity, etc. So here we're talking about how unions, what unions' obligations are in the way they represent their members. If a member feels that a union was discriminatory in the manner of their representation, then they may have a potential cause of action under either the DFR, the Duty of Fair Representation, or the Human Rights Code. And I raise that in this context because the chances of a member feeling that way are heightened in situations of member-on-member discrimination claims. So there's a substantive overlap between the obligation of the DFR and under the Human Rights Code. But the Human Rights Tribunal, at least, has been relatively clear that it only has a limited jurisdiction to address questions of the way in which unions represent their members. They've been quite clear, at least in Ontario, that a union's failure to bring for grievance, which is often the source of the claim, is not in and of itself discriminatory. And the Human Rights Tribunal only has jurisdiction to look at the issue if the choice not to bring a grievance forward or something else is based on or has an impact on a prohibited ground of discrimination, right? So it's only if the decision not to act comes from sexism or racism, etc., of the union, that the Human Rights Tribunal has anything to say directly on this matter. The second question is, what is the union's role, according to the law, in addressing broader situations of discrimination in the workplace? So now we're not talking about in the way they represent, but in the discrimination that's caused either member to member, by employer, etc., in the workplace. So the union, as we know, has this duty of fair representation towards each individual members and human rights obligations. And they must also make decisions in the best interest of the collective. And so that means that the obligations just discussed under fair representation and human rights is owed to each individual, where in situations of member-on-member discrimination, these individuals are opposed in interest. And so the big question for the union is, how do we properly represent both individuals and make sure we meet our obligations when they are opposed to one another? The court's point of view, or the position under the Human Rights Code, is that it is the employer that has the primary obligation to address workplace discrimination. And this is logical because it's the employer that has the capacity, that has the tools to make decisions to address workplace discrimination, right? The union has not the tools, generally speaking, to be able to effectuate change. The employer does. So that is their primary responsibility. the Supreme Court has held that the union only holds direct liability for workplace discrimination, again, not beyond their manner of their representation, only where it jointly negotiates with the employer collective bargaining terms which are discriminatory, or if it impedes the employer's reasonable efforts to accommodate an employee, what Elizabeth Schulten has termed contributory discrimination. And so the idea is, generally speaking, it's the employer who has the obligation to address workplace discrimination, and the union is only viewed as being a kind of co-creator of workplace discrimination, where it jointly negotiated a collective bargaining agreement term that is discriminatory, or whether when it blocks the employer for bringing in an accommodation plan that's reasonable. Well, that means that if we take all these pieces together, generally a union's role in addressing workplace representations is to avoid negotiating discriminatory terms, avoid participating in facilitating reasonable accommodation plans by the employer in regards to their members, and then representing members and pushing the employer to properly fulfill its obligations under the Human Rights Code, and representing members who are disciplined or dismissed by virtue and allegation of discriminatory comment. That is traditionally the boundaries of what the union's role would be at law, I should say, in addressing workplace discrimination. But
Hi, Claire. There's no other way to do this, so, you've got about three-ish minutes.
Fine, that's as long as I need.
Okay, great.
The difficulty is that when the union sits between two members who are involved in a dispute around allegations, it's less easy to say, or the union, may legally say that it holds no direct obligations for the creation of the workplace discrimination, but it now has more tools or is at least more directly implicated in the discrimination between those two members. And so when you have a situation of member-on-member discrimination, the union is all of a sudden brought much more directly into play in addressing the situation than it otherwise would be. And that is part of what complicates the entire issue. So what I'll skip to is, I guess, where this takes us. Judy and Larry Haven and myself are in the beginning stages of looking at trying to study, what different different unions are doing, what is the kind of standard practices, etc. But we haven't gotten there yet. And so what I have is a list of questions that it seems to me unions should be thinking through. And the first is to take seriously the idea that both members need to be represented equally in a member-on-member discrimination situation. I think there's often the tendency to assume that the complainant's interests are aligned with management, and that's really not clear to me. Management does not necessarily keep the complainant informed of what's going on, even if they're legally supposed to. A more complicated question, witnesses who aren't direct parties, but also don't understand what their role is and what's going on. So unions should carefully think through, who in the bargaining unit is affected and how do they want to figure out what their representational role will be there. The second thing is to have procedures in place before an issue arises that permits for the union to provide separate representatives to members who are in a conflict, and to figure out how they can separate communication flows within the union to permit for a kind of firewalled representation. And then it's also to have a big conversation about what should the union's approach generally be. It can shift in any given scenario, and some unions have this already. The Writers Guild I saw has a policy up on their website. But the question is, should the union be aiming at, generally speaking, at strict neutrality? And if that's the approach, then how do they, what procedures are necessary to ensure both parties are getting the equal representation? Should the union instead be making a decision about which about taking forward one party's case, one member's case and not the other? If so, how will that decision be made, and to ensure transparency in that process? To think through in what situations might it be useful for the union to represent one and potentially pay for separate counsel for the other to ensure that both are having equal representation. Some unions have negotiated joint investigation processes with the employers. So to think through the pros and cons of that, I can see that there is both. An obvious lawyer-like statement. I've talked to a number, informally, lawyers for big unions and asked them, do you think it's better to just sit back and say, you know what, this is actually the employer's problem? And uniformly they said no. They said they want to get on the ground as fast as possible and hear about the issue as fast as possible. And actually have the union be a big player in shaping how the whole issue is framed and put forward. And so that might be of use to you. And then I guess my few parting thoughts is that, unions may, and maybe, some will do this already, but think that addressing discrimination in the workplace is actually a collective interest. Sometimes human rights issues are treated as kind of individual interest, whereas the collective interests are things like seniority and discipline and discharge issues. But addressing discrimination is also a collective interest. And to think through, while I'm very much on the side that each member needs proper representation, the appearance of how this is treated can have a real impact on the union's legitimacy in the workplace, on solidarity within the bargaining unit. And finally, whether or not issues are, unions are perceived as championing issues of systemic discrimination in the workplace matters greatly, I think, to the future of the labor movement. And so, as Elizabeth Shilton put it, or the Supreme Court of Canada, discrimination in the workplace ends up being everybody's business, though a complicated and tricky situation to work through when the alleged discriminator is also in the bargaining unit. And that is all.
Thank you, Claire. And Celeste, do you want to bring yourself back on, both in voice and picture? Thanks. Okay, yes. Folks, so what we're going to do now is we're going to turn it over for the next, well, unfortunately, about 10 minutes. I think when we have two presenters, it makes it a little difficult to get as many questions as we'd like. And what I want you to do is, if you take a look at the dialog box for GoToWebinar, you will see something that allows you to put your hand up. And if you want to ask a question, put your hand up. While I'm waiting for, oh, Claire, do you want to just turn off your screen? And that way the audience can see us. Yeah.
Is that way?
No, I think your screen's still off. You have to share. You don't want to yeah, excellent. Okay, so I just wanted to mention a recent case that audience members might want to have a look at, because it canvasses a lot of the issues, and that is a number of complainants against CUPE, and I don't have the exact citation here, but it's the Saskatchewan Labor Relations Board. It's a duty of fair representation case. It involves a number of women who were working at the landfill at the city of Regina, who complained about harassment by fellow members of the union, male members, and they were being harassed not only sexually, but because they were whistleblowing. So it's a very interesting case. The labor board found CUPE, at least in part, guilty of representing their members unfairly. And the good part of it is I just wanted to mention that duty of fair representation cases have very, very low ratio of success across the country. Here in in Nova Scotia. I'm not sure, since the DFR came in about 10 years ago, if we've actually had a successful case of DFR. So the City of Regina case is a very interesting one. I'm still waiting for people to put up their hands. I don't see any hands. Yes, I do. Sheila Campbell has a question, and so I'm going to unmute you right now, Sheila.
Great. Can you guys hear me okay?
Yep.
Oh, great. Thanks very much, Larry and Claire and Celeste, for really, really interesting presentation. My question revolves around this idea of the reasonable person, and it's a question for both Celeste and Claire to maybe weigh in on. I feel that one could make a statement that the idea of a reasonable person changes over time, and that has implications for how legislation changes, how the body of common law is developed, and how our interpretation of legislation flows from that. And of course, there's always the interesting question of how the civil code in Quebec might make some differences. But it also then speaks to what's actually happening in the workplace, how employees view each other, how unions view their role, and so on and so forth. So I wonder if you could both maybe speak to this question of the reasonable person as a standard, and how that's changing, what that means for climate and culture in organizations, and how we move forward, particularly in this climate of Me Too and Time's Up and so on and so forth. Thank you.
Do you want to go first, Claire?
Sure. That question is actually one that there's a lot of, is an ongoing question in law, and there's a lot of analysis of that, you know, in different contexts, not just in the context of discrimination per se. Specifically in law, for instance, the test for figuring out whether there's been harassment, sexual, racial, whatever harassment, includes, you're supposed to look at it from the objective perspective of someone in the position of the complainant, whether an objective person in their position would view themselves as having been harassed, and whether an objective person in the position of the alleged harasser would know that that conduct was unwelcome. And who is sort of the objective person has been adjusted to be someone with similar characteristics to the claimant. And so in that sense, yes, it has completely evolved over time, and there's been kind of ongoing tailoring in law to try and address the fact that beliefs there have changed and should sort of match to societal expectations.
Mm-hmm. I think the concept of a reasonable person has become fluid, and I agree that when a nurse is saying that she has been bullied and harassed, a reasonable person might be perhaps another nurse in that same situation. Would she see herself as being bullied? So someone who has no involvement in the issue, either as a bully observer or target, what would they say about the situation if they knew all of the facts? And I think that's why we often have external interveners, external parties who are sent to investigate a situation to see what are the facts of the situation, and is it reasonable to conclude that this person has been bullied as a result of this series of behaviors.
Just to add just a last.
Claire, I'm just going to stop you there because I'm trying to get in two last questions here. And what I'm going to do is I have Vicky Scott and Johanna Westar. I may not get to Gunjinder Grewal, unfortunately. We'll see. But if I can recognize Vicky, ask your question, then I'll ask Johanna to ask your question. We'll see if because we're about 4 minutes from ending. So Vicky Scott, go ahead.
Hello, can you hear me?
Yes.
Okay, thank you. It's quite interesting. I've been I do workplace mediations and investigations. I've been doing it for about 20 years now, and I've had the privilege of working on the union side as an advocate and as an employer representative in my history. So my experience to date is especially since 2010 here in Ontario, where the health and safety legislation has compelled workplace parties to work collectively as it relates to managing workplace harassment, discrimination, and violence in the environment. And I've noticed the change in a lot of unions, and I need to congratulate them for stepping up when they have worker or member-to-member concerns. So there are a number of unions today that their collective agreements do have strong human rights language and joint committee type of language as it relates to health and safety, and also noticing how they do manage their members. And it's up to us as mediators and investigators to advise and counsel them on how to best represent their membership. And so if there's anything that, if you folks need anything with regards to research, you could contact us, mediators and facilitators and investigators, to basically introduce you to some of the best practices that are occurring out there. Then we can build on those best practices, because there's really no real rule book on how you manage this. We have the confines of the law, absolutely. But I'm up there for the offer. But I do need to congratulate openly some of the unions and how they manage the cultural differences in the workplace, the misfiring of communication. And again, we still unfortunately have gender-based harassment issues, regrettably, but they are working very well together. That's my observation.
Okay, thank you, Vicki. And I'm just going to move on to recognize Johanna Westar. Go ahead, Johanna.
Hi, can you hear me?
Yep.
Okay, great. Thanks very much. I think this question's maybe mostly for Claire. I just wonder if you have suggestion or advice about the idea of having kind of a firewall where the union can represent both parties. Would that kind of go through the system of having the grievance committees and grievance officers, do you think? Or is it better for unions to maybe have a parallel structure and where that would kind of flow from? And I'm not sure if there are examples in existence, because in a grievance committee, ultimately they do share a lot of information, and there's the single grievance officer. So I'm not sure if that's the right place or what.
So I think there's a lot of different models, but it strikes me, that's one of the questions why it's useful for a union to start with an idea of, are we generally going to adopt a strict neutrality approach, or are we going to try and make decisions? Because if you're adopting a strict neutrality approach, then I think things can still come in and through the grievance committee with sort of separated or firewalled representatives working with the individuals. Or sorry, the other way around. If you're not working with a strict neutrality approach, then ultimately reports will go up to that grievance committee to make decisions. If you are acting with a sort of strict neutrality approach, then you probably need an ongoing firewall, which is again going to be tricky at some stage. But that would be my sense. It depends a little bit on what approach you can use in order to have practices available for both situations. Does that make sense? Or does that clarify at all?
Yeah, I'm going to have to intervene here. We're at the hour. Sorry, I was going to say we're at 2 o'clock, which will confuse some of you, but we're at 1 o'clock, and that is the end of our webinar. I want to thank our panelists, Claire Mumme and Celeste Grimard, for wonderful presentations and for keeping to their time. I know it's very difficult. I want to thank our audience. This is a fascinating topic, and certainly the three of us on your panel today are going to be working on this on a continuing basis. And as Claire mentioned, we're very interested in finding out what is the state of the art for trade unions. So this is being recorded. It will eventually make its way onto the CIRA website and YouTube, and you'll be able to refer this to your colleagues or watch it again. Thank you very much, and goodbye to everybody.
Thank you.
Goodbye.
Bye-bye.